Calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, can you enter your appearances, please?
Chad Rumander, Ryan McBride, David Sturgeon, State, Mr. Jeff Gray, the County Attorney, and Chris Ballard are also present.
Good morning.
Good morning, Your Honor. Kathy Nestor, Michael Burt, Richard Novak, and Stacy Visser here on behalf of Mr. Robinson, who's seated to my right.
Good morning. Mr. Robinson, good morning. For the record, the court also recognizes the presence of Ms. Erika Kirk. Ms. Kirk, good morning.
Right from the start, notice how much time the judge spends on courtroom procedure instead of the allegations themselves. That might seem slow, but it's actually a sign of how high-profile this case is. Every rule announced now is designed to prevent mistakes that could later become grounds for an appeal. Have you ever watched a trial where the first several minutes were almost entirely about procedure?
First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until the recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. In addition, the microphones at your tables have been turned off. Again, in an attempt to try to minimize the possibility of any of the communications being captured. I ask that if you are speaking, that you come to the lectern, and that microphone will be live. And so that's the best way that we can hear you, and it is captured on the record. All right. Second, the court will address the camera operator, and the court knows there is no still photographer for today's proceedings pursuant to the court's ruling from last week. To our camera operator, would you please approach the lectern? My microphone, there we go. Now it's back on. Could you state your name for the record?
John Wilson, KSL News.
Mr. Wilson, what duties will you perform today?
Shooting the proceeding according to the decorum order.
All right. And have you had a chance to fully review the court's standing decorum order?
I have, sir.
All right. And you understand all the requirements set forth in that order as it applies to your activities today?
Yes, sir.
Do you require additional time to review the order or to adjust the equipment to ensure compliance?
No, sir.
Do you anticipate any difficulty complying with today's with the order or with any of the court's instructions?
No, sir.
All right. Well, thank you, Mr. Wilson. I appreciate you being here. Next, turning to the amended motion to allow the use of portable electronic devices filed by the news media and their counsel. The court appreciates the arguments presented in the motion and recognizes the importance of the press in the criminal justice system. Having considered the motions before the court, the request to permit representatives of the news media to use portable electronic devices.
Here's an important legal moment. The judge denies reporters the ability to use electronic devices during the hearing, but allows attorneys for the media to use them. That's a balancing act between public transparency and maintaining courtroom order. It also minimizes distractions that could affect witness testimony or the fairness of the proceedings.
During the preliminary hearing is respectfully denied. The request to permit counsel for the news media to use portable electronic devices during the preliminary hearing is granted. As officers of the court, counsel shall be held to the same standards applicable to the counsel for the parties and comply with the court's standing decorum order. I wish to turn to the matter before us today, the upcoming preliminary hearing, and the court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who are present. The court is also mindful of the duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that the portable electronic devices will not be permitted in the courtroom or on the fourth floor. In addition, each person who is in attendance will be afforded the dignity and respect due to them, and pursuant to the standing decorum order, all spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures.
Listen carefully to how specific these courtroom rules are. No reactions, no gestures, not even nodding your head. In emotionally charged criminal cases, even subtle audience behavior can unintentionally influence witnesses or create issues for the record. The judge is making it crystal clear that this courtroom will be controlled from beginning to end.
During the hearing. And the court recognizes that this hearing may invoke a motion from everyone, and that the court understands the human nature of that, but also it's important that this courtroom is orderly. Spectators shall not wear or display any pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case, or the status of this case as a capital offense. Turning to counsel. Before we begin, I want to acknowledge that over these past 10 months, I've had a chance to observe each of you, and I find that you are all competent, prepared, and that you care deeply about this case. I ask you to continue to conduct yourselves in accordance with the rules governing professional conduct, civility, and ethics. I also ask that you remain mindful of the constitutional rights of all parties.
This explanation about objections may sound technical, but it's incredibly important. A sustained objection means certain testimony can't be considered, while an overruled objection allows questioning to continue. These split-second rulings often shape what evidence ultimately reaches the court. Which side do you think usually benefits more from strategic objections, the prosecution or the defense?
And in every engagement, that you treat each person you engage with the dignity and respect they are inherently due, as they are human beings. I want to turn also to objections, the format that I wish to follow if objections are made. When an objection is made, all parties shall pause so that the objection may be heard. Speaking objections are not permitted. If any party believes that an extended argument is necessary, particularly on sensitive matters, that party may request to approach the bench, and all parties will approach the bench. Both sides will be afforded an opportunity to be heard for or against the objection, after which I will issue a ruling either sustaining or overruling the objection. Once the ruling has been made, direct or cross-examination.
The defense has just invoked what's commonly called the rule on witnesses, also known as witness sequestration. The purpose is straightforward. Witnesses shouldn't hear each other's testimony before taking the stand. That helps preserve independent recollections and reduces the risk of testimony being unintentionally influenced.
May resume. I anticipate that we will begin each morning at 9 a.m. with the exception of Wednesday, and we will begin at 1 p.m. We will take a 15-minute morning break and a 15-minute afternoon break. If there is a situation that necessitates a break, please approach the bench and we can address that. We will recess for lunch at noon for 1 hour each day, with the exception of Wednesday. And court will resume at 1 p.m. and continue until 5 p.m. each day. Does either party need the benefit of the record?
No, Your Honor.
Thank you, Ms. Nestor.
No, Judge, thank you.
Thank you, Mr. Gernander. Do either party wish to invoke the exclusionary rule?
Defense invokes, Your Honor.
All right. The defense has invoked the exclusionary rule. I ask that all witnesses, if present, be excused from the courtroom, and ask that each party monitor the courtroom to ensure your witnesses aren't present, as I'm not familiar with who they are. Of course, victim representative is excluded from that rule, as is the case manager pursuant to the rules.
With those preliminary issues settled, the hearing is finally ready to move into the evidence. Everything we've seen so far has been about protecting the integrity of the process before a single witness testifies. Now the real legal battle begins, where the prosecution will try to establish probable cause, and the defense will begin testing the strength of that evidence.
Okay, and I anticipate that from here on out, that they're just going to come to the lectern, so. Okay, so just for the benefit of the record, to the questions, the yes or no questions, well, the parties have entered their appearances, and they're all present, and neither party wanted the benefit of the record. Ms. Nestor invoked the exclusionary rule, and Mr. Grunander, if you'd like to approach the lectern as the microphones at the tables are not activated.
Thank you, Judge. Yeah, we anticipated that the defense would invoke the exclusionary rule. We consulted with defense for just a couple of minutes prior to the start of this hearing. We essentially have two case agents, Your Honor, David Hull and Brian Davis, both from the state of Utah. The defense has consented that both of them can be present. So one is seated at my table, the front table. This is Brian Davis, Agent Davis, and Agent Hull is seated on the bench just on the other side of the bar. He will be present for this hearing as well. Both of these agents will be testifying as part of the hearing.
Thank you. Ms. Nestor, and your microphone's dead. If you want to come forward, and it sounds like you've stipulated, but just for the benefit of the record.
We have stipulated, Your Honor, for purposes of this hearing only.
Thank you. All right, so Agents Davis and Hull are permitted to remain in the courtroom during the duration of the preliminary hearing.